Nevada. If we could just have a roll call.
Absolutely. Thank you, Chair. Vice Chair Durrett.
Here.
Justice Douglas.
Here.
Member Merritt.
Present.
Dr. Mazarana.
Present.
Chair Guzman Freilich.
Here.
Chair, we have a quorum.
Great. With that, we'll go ahead and go to our first public comment. Just a reminder to keep your comments under 3 minutes, and we'll do the south, we'll do the north, and then we'll also go online. And I know we've got instructions for online.
Provide public comment via telephone, call 669-444-9171. Enter webinar ID 810-7251-0418, followed by passcode 833747.
Okay, with that, we'll go ahead and have public comment in the south. Please come to the table and state your name for the record. Is there anybody in the south?
Yes, they're coming.
I'm coming. I moved a little slow in the morning. It's taking me a minute.
She sat in the back.
Thank you. Good morning.
Good morning. Good morning, board. I'm just here again to let everybody know that my name is Tara Baker, and I am representing Eco Weed Disposal Solutions, which will be a new waste management, cannabis waste management company that is coming to the area. Again, we are looking to be fully functional and operational by Labor Day weekend. So I just wanted to put our name back out there again, so nobody forgets me. Thank you.
Thank you.
Anybody else? Looks like that's it down south.
Okay, do we have any public comment in the north? Please state your name for the record.
Okay, am I under the gun yet? Can they hear me?
Yes.
Okay, my name is Craig Broderson, and I wanted to investigate what would be the procedure for a possible closed-door meeting of the board, and it's regarding what may happen if cannabis gets rescheduled to Schedule 3. I'm a member of the ASTM. I write standards for them. And I have worked in regulatory compliance for aerospace, medical device industry, and also the hemp industry. And I just don't know what to do or how to proceed with discussions with you people.
Okay, thank you. We've got your name. If we can get your email address or your phone number, then we'll have staff get back to you.
Okay, thank you.
Thank you. Any additional comment in the north? We don't have any additional comment. We'll go ahead and go online.
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining via Zoom. There's no online comment.
Okay, thank you. We'll go on to item number 2, which is the meeting minutes. We have one item under that section, which is the consideration of approval of the July 18th, 2024 Cannabis Compliance Board meeting minutes. If the board members have had an opportunity to review the minutes, if you have any comments, questions, or concerns, this would be the time. Otherwise, I'll take a motion for the approval of the minutes.
Member Mazarana makes a motion to approve the minutes.
Is there a second?
Member Douglas, second.
Any discussion on the motion? Hearing none, all those in favor say aye. Aye. We didn't hear the vote.
Aye. Aye.
Aye.
Aye. Okay, thank you. Motion carries. We've approved the minutes. And before we go on to the rest of the agenda, we just want to move the agenda around a little bit. We've got item 5, which is the consideration of a proposed settlement agreement to resolve disciplinary action. We're going to go ahead and move that to right before item 4. So right now we will do the consent agenda, then we will do item 5, and then we'll go on to item 4. So with that, we'll go ahead to item number 3, which is the consent agenda. We only have one item, so unless somebody pulls that item, we can vote after the description of the agenda. So Chief Gilbert, if you want to mention what that is.
Thank you, Chair, and good morning to you and members of the board. Steve Gilbert, Chief of Administration for the record. Agenda item 3A consists of a petition submitted by a conditional licensee to extend the 12-month period for final inspection by the CCB. Item 1 is for KV Group LLC, which was approved for a conditional independent consumption lounge in Nye County jurisdiction after passing suitability by the board in the August 22nd, 2023 meeting. On June 25th, 2024, through its legal counsel, KV Group submitted a letter to the CCB requesting a 12-month extension of the August 22nd, 2024 deadline for final inspection, which would be to August 22nd of 2025. KV Group reports experiencing significant delays in finding a suitable location in Nye County. It does report that the principal owner, while working with the local jurisdiction, determined that the front parcel of her residential property is zoned business opportunity and is eligible for KV Group to apply for a land use permit to operate a consumption lounge. KV Group anticipates preparation for and submission of the land use application, as well as Nye County processing of the application, will take 5 to 6 months. Staff have communicated to KV Group that there are no areas of concern, and Alicia Ashcraft and Juanine Villaslava are present today to address any questions you may have. Thank you.
Do board members have any questions?
Member Douglas, for the record,
Member Douglas?
as to this, we've been down the road partially before, but I noted in the letter from the Assistant Planning Director indicates pursuant to their county code, any cannabis establishment shall be required to have approval as the terms and conditions of a special use permit. And I was just inquiring whether or not they've had discussions with the county as that special use permit and whether there's any hiccups or. That's the only question.
Thanks so much, Justice Douglas. Alicia Ashcraft, the law firm of Ashcraft and Barr, on behalf of the applicant. And with me today is Mr. Stephen Cantwell and Juan Villa. Happy to answer any questions. I know they've had discussions with the county, so I'll let them take it.
Yeah, so our currently, the property that we're talking about is actually our home, is our farm. The whole concept is the farm to table lounge. We're actively working and building out our farm to be this beautiful oasis from the desert. The property is dually zoned. We've been working with all the local commissioners in the county, getting everything squared up, and had water rights to the property. A couple of little things, but we're actively working on it. We're not sitting on this license and lazy.
In the letter they wrote back, they talked about a special use permit. Are you required to have a special use permit on your property? I mean, the photographs are great and everything else, but I just wanted to know, had you had any preliminary discussions about whether you had to have a special use permit, and if so, would be problems or?
Yeah, no, we've had no issues with the county. They're very helpful. They definitely want to see the only amount of licensing in that county, so they're really working with us quite a bit. But yeah, we'll get the special use permit.
Thank you.
Any additional questions from board members? Okay, any comments from the applicant or her counsel?
Nope, thank you very so much.
Great. Thank you for being here for that clarification. I appreciate it. With that, we'll go ahead and bring it to the board for any discussion, or I'll go ahead and entertain a motion.
Here, Member Douglas, I'd make a motion for the extension that's been requested.
First, is there a second?
Member Mezrana seconds that motion.
Okay. Okay. Any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Motion carries. Thank you very much.
Thank you so much, and thank you to Chief Gilbert and staff for their assistance with this.
Thank you. Okay, so now we are going to skip down to item number 5, which is the consideration of a proposed settlement agreement to resolve disciplinary action. And, is it Mr. Rack? Okay. Thank you.
Chair, Vice Chair, members of the board, good morning. I'm Christopher Rath, Senior Deputy Attorney General. I'll be presenting agenda item 5A, which is the settlement agreement for the case of CCB versus Nevada Organic Remedies LLC. CCB case number 2024-14. This licensee is a cannabis cultivation facility operating in Clark County. Nevada Organic Remedies possesses cultivation, production, dispensary, and distribution licenses. However, the subject of the settlement agreement is only a cultivation license C094. At the time of the subject audit, the licensee held dual cultivation, medical and adult use licenses under the revised NRS 678B.215. Their licenses have been merged into one, which is number C094. Nevada Organic Remedies is currently operated via a court-ordered receiver and is also the subject of a TOI that the board will hear later today. With respect to this case, no complaint has been drafted or served in this matter. Rather, prior to the drafting of the complaint, CCB, through the Attorney General's office, contacted counsel for the receiver, and we engaged in settlement discussions. The drafting and service of any complaint and any subsequent answer deadline was held back as settlement discussions ensued. After such settlement discussions, the parties were able to reach a settlement agreement in principle pending approval of this board. Plus, there's no complaint that's been filed here. The allegations underlying this disciplinary action arise from a routine audit which commenced in June 2023 and concluded on August 2023. The key allegations against the licensee from the underlying audit include 2 failures to comply with seed sale tracking requirements, which included a failure to reconcile quantity of the plants and the wet weight documented on the harvest log with information recorded in metric the seed to sale tracking system, and a failure to reconcile the quantity of clones and source plants documented on the clone log with the information recorded in metric. And there was also a failure to meet electronic monitoring requirements for regulation. As set forth in the proposed settlement agreement before you to resolve these matters, responded to single category 5 violation for failure to comply with CCB requirements after pleading down the allegation for the violations alleged. Respondent also agreed to pay a civil penalty, the total amount of $10,000 within 30 days of approval of this settlement agreement approved. The CCB staff and council fully considered mitigating factors in coming to this resolution. Those mitigating factors are all listed out in paragraph 12 of the agreement, and the parties have agreed to weight each of the mitigating factors equally. CCB staff and council also fully considered the factors set forth in NCCR 4.030 subsection 2 in determining the amount of civil penalties to assess, which includes a consideration of the size of the business as well as the ability to pay. The pending sale was also a key factor as well as a mitigating factor. Given the violations alleged, the civil penalty amount is reasonable. Taking the matter to a hearing could have resulted in a much higher civil penalty, additional violations, and higher category violations. However, the CCB believes the mitigating factors did justify the agreed upon penalty. Respondent also provided a plan of correction, which is detailed in paragraph 25 of the settlement agreement, and CCB staff approved the plan. Licensee immediately implemented the plan of correction and now confirms that this relates in full compliance. This immediate rectification was one of the mitigating factors the CCB considered in determining settlement. Additionally, the TOI, if approved, there will be new owner managers in the facility, which is also a significant mitigating factor to consider. Based on the foregoing, the Attorney General recommends and requests the CCB approve the settlement agreement. Available for any questions, as is Mr. Savage, counsel for the receiver, and the receiver, Mr. Sanchez.
Great. Thank you very much, Mr. Savage and Mr. Santucci. Thank you. Do you have any comments?
Good morning, members of the board. John Savage on behalf of Shock Santucci, court appointed receiver over the source and its subsidiaries. We'd just like to thank CCB staff and council for working with us and reaching what we think is a fair and reasonable resolution to this matter.
Great. Thank you very much for your comments.
If the board has any questions, happy to answer.
Perfect. Okay. We'll open it up to the board for any questions, comments, concerns, both of staff or of Mr. Santucci and Mr. Savage. Okay, it doesn't appear like there are any questions, so we'll go ahead and bring it to the board for a vote. Is there a motion?
Madam Chair, Member Douglas, I make a motion for approval of the settlement agreement. From my standpoint, noting the cooperation of the licensee, corrections that were made in terms of training, cameras, and so on. Thank you for the cooperation. Approval.
Member Pratt, a second.
Okay, we have a first and a second. Any discussion on the motion? All those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Thank you very much.
Thank you.
Thank you.
Okay, with that, we'll go ahead and move on to our transfers of interest, which is item number 4 on our agenda. We've got 5 transfers under that agenda item, and we'll go ahead and have presentation with starting with Chief Staley.
Chair Guzman-Freilich, Vice Chair Durrett, Justice Douglas, Member Merritt, and Dr. Mazarana. For the record, I'm David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 4, which consists of 5 transfer of interest or TOI applications. Item A are TOI applications by Deep Roots Harvest, Inc. TOIs number 2400022 through 2400024 were filed requesting approval for the acquisition of various cultivation, production, distribution, dispensary, and consumption lounge licenses from the Source Holdings, LLC. The Source has been under a court-ordered receivership starting on July 25th of 2023, and Deep Roots will purchase all of the Source's operational and conditional licenses. TOI number 2400025 was filed requesting approval of a reorganization and recapitalization of Deep Roots, whereby Deep Roots Harvest, Inc. and Deep Roots Aria Aquo, Inc. will become subsidiaries of the holding company, Deep Roots Holding, Inc. The recapitalization component of TOI number 2400025 is a reflection of the reorganizational structure, but also includes an equity incentive component whereby Deep Roots will be issuing shares of ownership to numerous employees and advisors as an award for their contributions since inception. Deep Roots has also requested a waiver of NCCR 5.110 pursuant to 5.112. If approved, the requirements for prior board approval of a transfer of less than 5% ownership will be waived. The company has adequately addressed the items required in NCCR 5.112, and staff suggests that if approved, the board limit Deep Roots 5.125 waiver to expire at its next TOI agenda date. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Lori Rogich, Keith Capurro, and Brenda Snell are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you. Hello, welcome. I know we've gotten a little primer on what's going on here, but in your own words, let us know what's transpiring here.
Good morning, Amanda Connor from the law firm of Connor & Connor on behalf of the Source Holdings LLC and the receiver, Mr. Santucci. As Mr. Staley indicated, the Source is proposing the licenses that remain in its possession to be transferred to Deep Roots. I'm going to turn it over to Lori in just a moment, but before I do, I would request that similar to the RD 219 transfer, Justice Douglas, that you motioned in April, that the motion have that the receiver stay in place until the court approves that, which would give time for local transfers and approvals to occur.
Good morning, Madam Chair, members of the board.
Good morning.
Good morning, Chief Staley and Agent Adams. My name is Lori Rogish, and I'm here on behalf of Deep Roots Harvest. With me today, I have Keith Caporo. Mr. Caporo is an owner, board member, president, and CEO of Deep Roots. Next to him is Dennis Smith. Dennis is our treasurer and chief financial officer, and also an owner. Next to Dennis is John Marshall. Mr. Marshall is an owner and our chief operating officer. And next to John is Brenda Snell. Mrs. Snell is our chief administrative officer. Thank you for this opportunity. We appreciate your patience and support as we come before you today with one of the largest cannabis transactions in the state. We are proud to be here, and we ask for your approval of our reorganization and the acquisition of certain licenses that are currently in receivership. We are excited to be in this position and are available for any questions that you need. Thank you again.
Thank you so much, and I appreciate you introducing and having your members there today for us. I'm sorry that we're not down in Las Vegas, but we are here, and this is good for today. So I appreciate that and welcome all of you. And I also appreciate this is the example that we look forward to having before us, which is, businesses that for whatever reasons were not able to make it in our state, but we have a business like yours that comes in and is able to pick these businesses up and make them productive and employ people or keep people employed and just keep our economy going. And I am very excited about this transaction. And with that, I'll just open it up to the rest of the board members.
Member Durrett, it's what the chair said. Deep Roots has always been very impressive, very well run, very involved in whatever community organizations, community events. They've always been available to give feedback on businesses. Do you think part of that is because of the gaming background of some of the owners? Do you think that's been a large part of the success? I'm just curious. I know you've asked these kind of questions before, and it's, I know the owners just really, some good businesses have gone out of business, and this market is so tough that it's not easy to just point to one thing that's the secret of your success. But do you think maybe that's had something to do with it, or? To let Mr. Caporo answer.
Oh, thank you. Thanks for the question. I think that definitely the compliance background that our partners have certainly plays a role. I think part of the success also is just related to the conservative manner in which we run our business, right? We've tried to apply really sound business principles and not get fancy, try not to spend too much money, and try to preserve our cash flow. So I think certainly the gaming background has been helpful, but just sound business practices, not getting fancy, holding on to cash has put us in a good position.
One other comment, I don't want to indicate that other businesses weren't doing it right, because I think there's just so many challenges in the industry that have been thrown on these businesses that even people who have good businesses have succeeded in the industry. But it's great to have this Deep Roots still around and stay in Nevada, okay? Don't sell out, okay?
Thank you. Any additional comments?
Member Douglas, for the record, based on what's been offered, so you would like approval by this board, subject to approval by the district court and allowance until conclusion of, I guess, the receiver business.
I believe the court has approved the transaction, but when we came before with the other license in Reno, it was that, the transfer was approved conditioned upon closing and I forget exactly how it was phrased, but the receiver to stay in place until the court released the receiver.
No, we need the local approval.
And local approvals, which would be, the court wouldn't release the receiver until local approvals are obtained.
So we can release the receiver on CCBs, and if the court's good with it, and we can do that without a vote if necessary, because that's the way we did it on the Reno license.
That's exactly right. We're looking to do it very similar to how the Reno license was held, which was.
So once the court approves the removal of the receiver, you let us know, and then I think we can issue an order releasing him as a receiver, then he would return his CCB.
In what they had offered us, there was a fact that there's things that weren't closed yet and were closed, so that was a question about how they should be phrased, our approval, to make sure we cover it correctly.
I will defer to Mr. Savage, but I believe the request is that it be conditioned upon the receiver staying in place until the court releases the receiver, which then we would notify you that the court has released the receiver over these licenses, and thus CCB can release the receiver and he turn in his agent card.
Amanda, if I may, Jackson Tucci, the receiver. So the court already approved the transaction, but the issue could be that after the approval today, the CCB staff will be looking at us, rendering our cards, but we still need for the transaction to get local approval so we can get a closing. So we don't need approval from the court for the closing. We just need to wrap up all the details with the local jurisdictions. So one day we have a closing, count the inventory, do the transfer metric, and then at that point, the source, the receiver staff is out, and then the deep roots harvest can take over. So that's what we did for Reno a couple of weeks ago. On July 31st, we had the transaction, and then we sent the card back a few days later.
Right, and we can do it two ways. We can also, once everything's closed, we can also do a CCB, release of the receiver contingent on court approval, so that either way.
John Savage, counsel for the receiver, and just to clarify, in the court approval of this transaction, subject to CCB and local regulatory approvals, it does specifically authorize the receiver to essentially take all further actions necessary to consummate the transaction without further order of the court. I believe that the new CCB receiver regulations allow the board to remove the receiver without a formal vote on it.
Correct.
And so I think once we obtain, the way we did with Reno, once local regulatory approval was obtained, notified the CCB, and we also notified the court, and then the CCB issued its order releasing the receiver over those licenses. The receiver
I think it was pursuant to court approval too.
Well, it was.
Which is, the court's got to release them at some point, so.
Yes, well, the order we already received from the court allows the receiver to take these actions without further order, without going back. So we have it sort of built in. We're just notifying the court once these transactions are completed. And then the receiver is staying as over these companies, just without the licenses. So we're just going to ask for the receiver to be discharged from the licenses once local regulatory approvals are obtained.
Right, and once we get that notice.
And closing.
Yeah.
So, I guess what I'm hearing is the request is that the receiver stay in place until closing occurs and the receiver notices the board that just happened.
Yes.
That would work.
Yes, thank you.
In order to close, we have to have a local approval as well, so.
Madam Chair, if you will, make a motion for approval, subject to local approvals and outstanding conditions of the court. And this waiver of application pursuant to NCCR 5.110, pursuant to NCR 5.112. Hopefully that covers what we hope to cover.
I think so.
That sounds good. Do we have a second?
Sure. Member Mesrata seconds that.
Okay, we have a first and a second. Any discussion on the motion? Okay, I hear none. All those in favor say aye. Aye. Any opposed? Motion carries. Congratulations and thank you so much. We wish you the best and thank you all for being here today.
Thank you for your kind words and we appreciate all your efforts.
Thank you. Okay. Now we'll go ahead and go on to item B, which is Green Mining Concepts, Inc. Chief Staley.
Chair Guzman Freilich, members of the board, for the record, I'm David Staley, Chief of Investigations. Item B are TOI applications by Green Mining Concepts, Inc. TOIs number 2300041 and 2300042 were filed requesting approval for Green Mining to sell its Exhale dispensary to William Barth and his company, Blue Star Partners LLC. Exhale holds cultivation, production, and a dispensary license, although its cultivation and production licenses are currently non-operational. Barth is a current owner of Green Mining and a significant Green Mining creditor. The sale of the Exhale dispensary to Barth will satisfy over half of the debt owed to Barth by Green Mining. An area of concern was developed during this investigation. Green Mining, through its subsidiary Exhale Brands Nevada LLC, owes the Nevada Department of Taxation over $900,000 in unpaid taxes. The Nevada Tax Commission met yesterday and approved a payment plan with Exhale. In addition, as part of the proposed purchase of the Exhale dispensary by Barth, Blue Star paid over $600,000 to taxation for the benefit of Exhale Brands as part of its acquisition. I am available for any questions, and my understanding is that Brian Hardy, Peter Findley, and William Barth are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Right, thank you very much, and thank you for being here, Mr. Hardy. I know you've got your clients there. Explain to us what's going on here and the economics behind this, because it's my understanding, unless I'm missing something, but you lent money, and in return for that money, you will go ahead and forgive half of that money, but then you're also going to pay some of the majority of the tax, outstanding tax debt that's owed. And then in return, you will get one of the dispensaries. Is that correct?
Sure. Members of the commission, Brian Hardy with the law firm of Marquis Arbach on behalf of Exhale. And we also have Adam Fulton on behalf of the proposed purchaser, Mr. Barth's company, Blue Star. With respect to what's going to be occurring here, Mr. Barth has been, previously he was one of the major funders for a banker, effectively, for the company. And then about a year ago, you saw him acquire an interest in the company in order to satisfy certain amounts of that debt. And then as a result of the ongoing obligation, additional debt came due and owing. And in order to negotiate with him, in order not to foreclose on that debt, we were able to obtain the forgiveness of an extension on some of that debt in exchange for the release of this particular license to him individually, as well as in exchange, we wanted to make sure we were taking care of the tax obligations. And so we obtained from him a commitment, which is reflected in the first amended escrow instructions, which have been, I believe, provided to the board. The commitment of him to pay the principal amount of the remainder on the tax obligations of the company, which is the amount of $612,000 and change, which he is agreed to release, and he's actually posted in an account to be released within 10 days following approval. And so we went to the Board of Taxation to get them approved for the remainder so we'd have a payment program on the remainder of the principal and interest during that interim time, and we have submitted a request over to taxation for a waiver or consideration of a waiver of some or all of that principal and interest as we're continuing to reorganize the financial obligations of the company. that was submitted, and after yesterday's approval of the tax plan, I spoke with taxation, Kathy over there, and she indicated that she has received our request for a waiver. However, unfortunately, due to the systems with taxation, and probably because I'm a lawyer and I typed too many words, it wasn't able to fully read all of it, so I have to go submit it in person. She just asked for a full copy because I guess I got wordy in my application. And so I will make sure that that gets over there along with, and we've talked with Mr. Fulton. I'll just personally drop off the check to taxation when I go give that waiver. They've agreed to receive that. I'll be meeting with Kathy to handle that in short order. So all of the principal of the taxes we paid as a result of this, Mr. Barr's loan will be substantially reduced and extended out on any remainder balance that we have so that we can get this matter reorganized. And so that at the end of the day, we will be continuing to seek either a waiver and in order to use the remainder of the assets of the company or operations of the company to pay off any residual. Hopefully that answers the question. And again, I can be wordy, so if it did, I apologize.
Member Douglas, for the record, just remember periods at the end of sentences are a good thing. I'm glad that you reconciled the tax issue. That was the major stumbling block. Other than that, it seems in good shape.
Yes.
Adam Fulton for the record on behalf of Blue Star Partners, law firm Jennings Fulton. This is a good example in our industry of people being able to resolve their differences instead of going the court route and appointing a receiver and dragging it out. And we really appreciate staff's help in navigating some of these complex issues, which maybe are not par for the course, in order to do something that does not require court intervention. And so I would like to thank the staff and there was a lot of staff that helped us get through this, not only here, but over at the Department of Taxation to make this possible. And I think it is really a great thing to see in our industry.
And I echo that same support, and the Attorney General's office has been phenomenal with both the taxation and the CCB, and so they've been phenomenal to be able to work with that and see that, it's not always the best option to appoint a receiver and go through court proceedings, so that can get expensive for companies. So.
And can kill jobs, to be honest.
And thank you, and I commend you, and I commend our staff as well, in doing this the most positive way, as well as, creating that escrow account and not having any monies transfer until everything's been approved. So what a novel idea, right? But you'd be amazed at how much money is transferred without approval, which is a no. So thank you for doing that. Any additional comments from board members?
Member Dredd, so the remainder of the debt, they're gonna pay that off through, they'll keep a cultivation and a production facility, but are those operational and making tons of money to pay off the rest of the debt?
They're not operational this time, so one or two things will happen. Either they can then reorganize them to make them operational, and they can go ahead and look for a buyer to purchase those as they continue to liquidate assets one way or another. But we're working to reorganize to make sure that we can get everything taken care of on the payment plan. And again, we entered into a payment plan for the total amount. That's what was required, but we have this amount that's going to pay down a significant portion of that, all of the principal, right? And then we're seeking also the waiver to hopefully reduce it further as we try to work with them to taxation, to hopefully forgive at least some, if not all, of the principal and interest, so that we can continue to move forward.
Yeah, I guess it does seem like a better step than receivership, avoiding going into receivership, and seems extremely proactive of the attorneys and the licensees to avoid receivership. So I guess that's positive, but it's also unfortunate. I had another question. Who's going to continue to manage? Who's going to be their management team? Because I don't think Bart is running it, right? So it's the current,
Our plans at this point are to keep current staff in place and evaluate staff moving forward. But as of right now, there are no plans to fire anyone or keep everyone. We're just going to try to keep running the businesses.
Okay. Any additional questions or comments? Hearing none, we'll go ahead and take a motion. Is there a motion for approval?
Member Douglas, motion for approval of the transfer of interest.
Is Is there a second?
Member Merritt, I'll second.
Okay, we have a first and a second. Any discussion on the motion? All those in favor say aye.
Aye.
Aye. Any opposed? Okay, motion carries. Thank you.
Thank you
Good
so
luck.
much.
Thank you.
Okay, now we go on to item C under this agenda item. Chief Staley.
Chair Guzman Freilich, members of the board, I'm David Staley for the CCB. Item C or TOI application by GL Partners, Inc. TOIs number 2300035, 2400013, and 2400014 were filed requesting approval for GL Partners to purchase cultivation, production, and dispensary licenses from MedMen Enterprises, Inc. and Curaleaf Holdings, Inc. GL Partners currently operates in Missouri, Arkansas, Illinois, West Virginia, and South Dakota, and these proposed purchases will mark GL Partners' first-time entrance into the Nevada market. On April 26, 2024, MedMen filed for bankruptcy under the Canadian Bankruptcy and Insolvency Act and has been liquidating assets. One of those assets, a dispensary held by MMOF Fremont Retail, Inc., is being sold to GL Partners. Pursuant to a second agreement, Curaleaf is selling subsidiaries Acres Cultivation LLC and Acres Dispensary LLC, which hold cultivation, production, and dispensary licenses to GL Partners. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Amanda Connor, John Mueller, and James Mueller are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Great, thank you very much. Thank you and welcome.
Good morning, Amanda Connor with the law firm of Connor & Connor. I'm here with John Mueller. Thank you to Chief Investigator Staley. He is correct that it is GL Partners, Inc. first time entering the Nevada market, although they were here for a management services agreement a few months ago. But it is not John Mueller's first time entering Nevada. In fact, he was one of the original licensees and is excited to return. This is involving a purchase of two different companies, a dispensary, cultivation, production, and a second dispensary. And just so you are aware, the GL Partners does have another pending transfer of interest. So we'll hopefully be back in front of the board soon with additional acquisitions. They are very excited to be in the Nevada market, and we are here to answer any questions you may have.
Wonderful. Thank you so much. And thank you for being here and welcome again. So tell me a little bit about why Nevada?
One, we got our start in the cannabis industry here. So back to the medical program, converting to adult use under the name Acres, which is, we're going back. So one of these transfers, or actually two of these transfers, are Acres Cultivation out in Amargosa Valley. Sold that to Curaleaf in 2019. And have had the opportunity to come back and repurchase that. So actually yesterday, 3 of my employees are still there from the old days, which is good. And Curaleaf was getting ready to shut that down. So we're excited that there's 29 people working out there as of yesterday that were not going to be employed, which is exciting. We're going to build that up out there and then also the Ely dispensary as well. I sold that to Curaleaf. So it was an old Acres deal that I was the co-founder of back in the day. And so happy to get those assets back. And then obviously MedMen, troubled asset deal, which is what we do for a living. So the MedMen deal in Paradise is under management services agreement. It's been going extremely well, rebranded. We're starting to grow that. We about tripled the sales down there from where it was at. That was shuttering as well. So a bunch of new staff down there as well. So we're excited about that. And we have another one that's coming before you, but really excited to be back in the market. We think we were good operators when we were here, never had any issues. And right now, Greenlight is the brand name we go under. We've got about 750 people. And I really was the first employee for Acres out here in the cannabis industry. So we've built up our cannabis business over, and actually Ohio is another state that we just added. So we continue to expand our business across the country, and private company, we pay dividends, we have no debt. Trying to be a good operator and steward for the industry.
Great, thank you. As Member Durant would probably say, you're one of the OGs. So appreciate you coming back and having faith in Nevada and helping some of these struggling businesses. So I appreciate that. Thank you. Any additional comments or questions from the board members?
Member Durant, I think our metric for whether Nevada is doing well is if we can suck John Mueller back in. And so I'm glad to see we sucked you back in and been a great operator, so I'm glad you're back.
Member Mazzaron, do you live here?
I do not. I live in Kansas City. So back in the Acres day, I moved out here and drugged a wife and 3 kids and went back to Kansas City now. So we'll have a team on the ground and actually the bulk of our business is in the Midwest there. And so we're starting to expand across the country.
But you will visit often.
Yeah. Well, I don't have a choice, but
That's what I was looking for.
I was saying going to be out here, but we have, I guess 33 dispensaries open now across the country. So I won't be here as much as I was before, but, and my wife will allow me to move back. So I apologize for that, but I'm married. So.
Another question. How much time and effort goes into preparing for potential interstate commerce? I mean, it could be 10 years.
Yeah, I think my kids will own this business and they're like 8 right now. So before that ever happened, so like, I think it's a long way. I think it's a couple decades out before interstate commerce ever happens. And, states like Missouri where we're very active there and, in the Constitution, it doesn't allow, basically interstate commerce, or they'll comply with the same rules, and how you would do that, I think it's just going to be an absolute mess. So I don't see that happening anytime soon with rescheduling or anything else. I think the FDA will work with groups like you guys on the rescheduling front and figure out how that impacts us, as we'll still be federally illegal when that happens. We just get better taxes, I think. It's the main portion of it. So hopefully that happens this year, but we'll see. We're running out of time in the year, I guess.
Wow, that's interesting. That's not what I expected.
Yeah.
With 33 dispensaries across the country, I would.
We like to be in limited license markets. You look at like in Oklahoma where they give out licenses to everybody and they can't regulate. You guys would never be able to do that. And we avoid states like that. We like to come back to Nevada. We see a lot of people running out of here and we're running in. So we think it's a good opportunity for us as business owners and pick up some assets that people no longer want. And we think we can turn them around. That's what we've done in our past.
Great. Okay, any additional comments or questions from board members? If not, then I'll entertain a motion.
Member Douglas, for the record, appreciate good folks coming back to run businesses. I move for approval, transfer of business.
They do have a 5.112 waiver.
I would add that as part of the motion for approval, the request pursuant to NCCR 5.110, pursuant to NCR 5.
Waivers, can we have like a or something? Okay.
Member Mazzaron, seconds that.
Thank you. We have a first and a second. Any discussion on the motion? All those in favor say aye. Aye. Any opposed? Motion carries. Welcome back.
Thank you. Thank you all for your time and what you do.
Thank you to Michael Covington and Chief Investigator Staley. They did a great job on this.
Thank you for your comments. Okay, we'll go on to our agenda item D of item 4. Chief Staley.
Chair Guzman Freilich, members of the board, David Staley for the record. Item D is a TOI application by Waveseer LLC. TOI number 2400002 was filed requesting approval for Waveseer to sell its Henderson dispensary to Natural Medicine LLC. Waveseer has also requested a waiver of NCCR 5.110 pursuant to 5.112. If approved, the requirements for prior board approval of transfers of less than 5% of Waveseer ownership will be waived. The company has addressed the items required, and if approved, staff suggests the board limit Waveseer's 5.125 waiver, 5.112 waiver to expire in its next TOI agenda date. An area of concern was developed during this investigation. WaveSeer, through its subsidiaries WaveSeer of Las Vegas LLC and WaveSeer Nevada LLC, owes the Nevada Department of Taxation over $1.35 million in unpaid taxes. The CCB, Taxation, and WaveSeer have entered into a conditional TOI agreement which, if approved by the board, provides that Natural Medicine will remit all funds for the proposed dispensary purchase directly to the Department of Taxation to pay all WaveSeer's outstanding taxes, penalties, and interest. If there are any amounts left, taxation will remit those funds back to WaveSeer. I am available for any questions, and my understanding is that Alicia Ashcraft, David Rosen, Donald Fordman, and Lisa Clements are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you, Chief Staley. And before we go on to questions, I just want to make sure that when we do a motion on this item, it's two or one motion with two items. Basically, it's the motion to approve or deny, depending on how the conversation goes, but motion to approve and approve of the conditional TOI agreement. So we do have to approve not just the transfer of interest, but also the conditional TOI agreement. And with that, Ms. Ashcraft.
Thank you, Chair Guzman-Freilich, Vice Chair Durrett, members of the board. Alicia Ashcraft of the law firm of Ashcraft and Barr on behalf of the licensee WaveSeer of Nevada and also WaveSeer of Las Vegas that is party to the conditional TOI agreement with me. Here in Las Vegas is manager and CEO David Rosen. Happy to answer any questions that you may have. I'd just like to thank and acknowledge CCB investigators Dana Lauren and Danny Sandrock for their diligent and expeditious work in getting this before you as quickly as possible. Again, happy to answer your questions.
Thank you. Do we have any questions from the board members?
Member Dredd. So what is the conditional TOI agreement? Is this the state saying, okay, we have multiple agencies involved here, so we need to all get on the same page to orchestrate this? What's the nature of the conditional TOI agreement? Because I don't remember seeing one of these before, and it seems unfamiliar to me to have, state involved in your transfer. So how does all that work? I guess
I can probably answer some of those questions. There was one conditional TOI agreement before, but it was of a different nature. That was for like MJ agreements. This one's a little different. I mean, basically there's a requirement for them to be in compliance with taxation until there's a renewal. They were coming up for renewal. There was a pretty heavy tax burden there. So the agreement had to be made with tax. So they were comfortable saying that these people were compliant so that we could renew their licenses. And as part of that, it also solves the area of concern of how you're going to pay all these taxes. So this was worked out with taxation and CCB, the licensee and buyer. I think it even includes an ability for the buyer or the WaveSeer to contest the amount of taxes too. So that's why it's a bit more detailed. That's basically in a nutshell.
So it kind of, the inspiration for it was the state saying, okay, we want to work with you, but we want to make sure these taxes are paid if we work with you on.
Exactly.
Okay. On not renewing your license. Okay. And okay. Did you want to add anything to that or?
Thanks so much, Vice Chair Durrett. I just want to clarify a couple of things. One is the licensee did offer to put the proceeds of the transfer in an escrow account, so we did offer that. This was really a finite period of time that this took place last year. The licensee was in constant contact with the Nevada Department of Taxation to work out other ways to catch up. On current taxes, I think the majority of this year, they're paying currently. So it's just a matter of getting caught up on that period that took place last year. They tried a couple of things. They tried to right the ship. Those didn't work out. So they made the very hard choice of having to sell one of their facilities. So this transaction was designed exactly for that purpose. They're selling to an existing licensee at a discount to get it taken care of as quickly as possible and to get caught up with their obligations from the state. So I just want to be very clear that we were transparent from the beginning, that that was the purpose of this transaction, was to get to that point. The agreement was a requirement of the Department of Taxation. And we couldn't get this item before you but through this mechanism. So again, happy to answer any questions, but I just want to make it clear that at all times, Wavesphere was doing and making hard decisions to remedy those deficiencies in its obligations to the state.
Chair, can I make 2 more comments and 1 more question?
Oh, I'm sorry,
No,
can
that's a lot.
can I just say 2 more things real quick? I just want to clarify a couple of things. One, this agreement does not give Wavesphere the ability to contest the amount of the taxes. That is actually something we had to agree to. The only thing that it allows, which as a taxpayer, they would be permitted under the Taxpayers' Bill of Rights to do anyway, is request a waiver of penalties and interest when the tax is paid. So it just acknowledges that ability, which it already has under the statutes anyway. Also, just to clarify, not to contradict Chief Saley, but the base amount of the taxes is being paid by the buyer directly to taxation. Taxation of the CCB required that any remainder of the proceeds be placed in my trust account. So that will be paid into my trust account until the decision on the waiver of penalties and interest. Then those proceeds can be taken from my trust account to either pay for whatever portion the tax commission determines is still due and owing, and then any remainder after that can go to the licensee. To be clear, the proceeds based upon the numbers that we've gotten from the Nevada Department of Taxation are more than sufficient to, even if it had to be 100%, more than sufficient to pay all of those obligations.
I'll just can make these comments quickly if that's okay, Chair.
Absolutely.
One, it's good that there was experienced counsel involved in this because there was so much that went into this. And it's, again, just like the last one, great that you avoided receivership or fire sale or bigger problems. It's really, this one is very sad because this has been a great principled operator since the beginning. They brought in a union, which not everybody, wants to take that path or supports that, but those were their principles and ideals and they put that into practice. And so I hope this rights the ship for them and that they do well going forward as a result of all of this. I just have one more question. So if we have this was just narrowly all came together perfectly at the very end, but if we had a situation where there was a renewal due and they were in the midst of a sale to be able to pay their taxes maybe, or would it come to the board to determine whether or not they would get their renewal versus the renewal being denied by staff?
Well, I think we try to work out an agreement like this.
But if it couldn't, do renewals come to us? If there's, okay, so for example, if we suspend a license, if you suspend a license, it comes to us. I think if you don't approve a renewal for non-compliance, that's similar to suspending a license. So does that come to the board?
I don't believe so, but according to the regulations, if they don't comply with renewals.
Can we look at that regulation and can we?
Renewals have very limited things you have to do for renewal. One of them is be compliant with the Department of Tax. If you're not compliant with the Department of Tax, you'll get renewed.
That's
that's in the regulation.
It's to be compliant in general, right? So you have to be compliant with every law on earth to be renewed, right? Because
Specifically.
It is specifically for the
Department of Tax. Yeah.
Okay. All right. Well, I'll go ahead and pull it, I guess, for future discussion if I have further questions. Okay. Thank you.
Any additional questions or comments?
We're done with simple question. What are you gonna do with the business?
Jeff and David here appearing on behalf of Natural Medicine LLC. Also with me is Lindsay Clements. She is Director of Operations. We are going to be submitting a remodel modification request to you most likely next week. And we will have it remodeled, and our goal is to open it by November.
I'm sorry, Member Douglas, did you have a follow-up?
No, I was going to say, Madam Chair, unless you're looking for a motion.
That would be great. Yes, please.
Thank you for your words early on. A motion for approval of the transfer of interest. And also, can we do it jointly? Also approval of the conditional TOI agreement.
And I'm sorry, Justice Douglas, in the 5112 waiver.
In a waiver,
as well,
yes.
on behalf of waiver.
That would be my additional recommendation for motion as the 510 waiver.
Member Mezrine, seconds that.
And we have a first and a second to approve the transfer of interest and the conditional TOI agreement as well as the waiver. Any discussion on the motion? All those in favor say aye. Aye. Any opposed? Motion carries. Thank you so much. Good luck.
Thank you.
Thank you. Okay, on to our last transfer of interest. Chief Staley.
Chair Guzman Freilich, members of the board, for the record, I'm David Staley with the CCB. Item E is a TOI application by Lander Leaf Growers LLC. TOI number 2400006 was filed requesting approval for 1% member John Hallmark to sell his 1% membership to Karen Conder, who will then be a 50% member of Lander Leaf Growers. An area of concern was developed during this investigation because it appears that Hallman was paid for his membership in August of 2021 in an unapproved transfer of interest. I am available for any questions, and my understanding that Joseph and Karen Conder are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Great, thank you very much. Do we have Mr. and or Mrs. Conder available in the South or by phone or Zoom?
We have someone with their hand raised, but they haven't identified themselves. I'll give them permission to talk.
Okay, great, thank you.
Hi, this is Brand Conder, owner of Lander Leaf Growers. Can you hear me?
Yes, we can. Thank you, Ms. Conder. Do you have an affirmative presentation for us, or are you just available for questions from the board?
I would like to say that my husband and I had this dream of coming into the cannabis industry. We had a farming background, but we didn't have any experience in the cannabis business. And we had limited, we're a small operator. We had lots of obstacles. And when we were going to do the transfer of interest, we had a prospective buyer and a deal going. And then when that deal fell through, we were struggling. And so we thought, well, it's best if we focus on raising the money to renew the license, and then we'll deal with the transfer of interest. And I guess you just have to say that inexperience, I just didn't even occur to me not to give the money when we went to notarize the agreement. I just, in my head, thought that, well, it's not going to be legal until the board approves it. I didn't understand that the exchange of money was doing it without, basically. So operational at the beginning of this year, but we did have an opportunity present itself to maybe go operational again at the beginning of next year. And we're just trying to do everything and dot every I, cross every T to try to give it, one last chance. So we we apologize and
You there? Ms. Condor?
yes.
Oh, okay. I thought you broke off.
Oh, were you able to hear me at all?
Yes, we did. And we heard your apology, and I just didn't know if you said something after that.
No.
Okay. All right. Thank you. I'll open it up to the board for any questions that they might have. Any questions from the board members with regard to the transaction before us, or anything else as far as future plans?
Member Durrett, I guess I would make a comment to the owner that I do want to see small, family-owned, DIY businesses succeed in this industry, but it is so law-intensive that doing it without somebody who knows regulatory compliance can get you in a lot of trouble and get your license revoked. So if you don't want to pay for an attorney, you need to get on top of the rules or consult with somebody who knows them.
Are there any additional comments or questions? Okay. If there are no additional comments or questions from the board members, Ms. Condor, do you have any additional questions for us or comments before we take a vote?
Still?
Yes.
Okay. Yeah, we realized pretty quickly that we were in a little over our heads, and we did try to bring in some experienced people, and our potential opportunity at the beginning of the year is with people that are experienced. So we do understand the difficulty here.
Thank you. What's your plan for the future?
Well, the county has just approved a dispensary, and a cultivation, if they're not lined up with a dispensary, really doesn't have anything. So we have hope that if we can work with the people coming in with that we'll have a chance.
Okay. I appreciate that. And I wish you the best. As Member Durrett said, we really hope that anyone who, has the vision in the state, that they are successful. And so we really hope that you are successful, and hopefully that dispensary is able to utilize you.
Thank you.
To become operational and successful.
Thank you.
Thank you. Any additional questions? Okay, I'll entertain a motion.
Member Douglas, for the record, echo the words of Member Durrett and the chair in terms of where you're going. It's good to see one of our rural counties having activity. I would make a motion for approval, and that find no violation at this time as to the premature transfer of funds. That would be my motion.
Is there a second?
Member Merritt, I second.
Thank you, Member Merritt. With that, any discussion on the motion? All those in favor say aye. Aye. Any opposed? Motion carries. Thank you and good luck to you.
Thank you.
Okay, now we're gonna jump, not jump, but we already took care of item number 5. So we're gonna go to item number 6, which is the briefing from the chair and the executive director. And it's nice to have you here, Director Hum. It's nice to have half of our people up here and have you spending some tax money in Washoe County and Carson City.
Excellent. Thank you, Chair. It's good to be here, but of course, miss the team down south as well. Excuse me. Nothing too substantive today. Just wanted to say again, thank you. Special thank you to our legal team. As you can see from a lot of the transfers of interest, a lot of work went into these, which is a follow-up to Chief Staley and his team as well. Their investigators just do an incredible amount of work on all of this, and it's always amazing to see when it comes together. And honestly, a thank you to industry as well. The 5 that came forward today worked very closely, obviously, with both our legal and our investigative teams. So kind of that cohesion is really what makes it work. And so for those that don't see all the work that goes in behind the scenes, it's an incredible endeavor. And again, in this particular case, with these transfers of interest, with the legal, investigative, and industry really coming together to work through these to present them concisely to the board. So really, again, as always, a huge thank you to everyone. Couldn't appreciate them more, and it's just a pleasure to work with all of them. And as I always echo, I got the best board in the state. No offense to the other boards, but thank you to everybody. And Chair, I'll turn it back over to you. That's all I have.
Thank you. And I know it's a short meeting, so I'll just mention too, I don't know, not very many people know that the Attorney General's office, even though the DAGs are not employees of the board, they are employees of the Attorney General's office, but it is so nice to have them in-house. I can't even imagine on a day-to-day basis. It's just to have them so available. So thank you to that arrangement, with the Attorney General's office to be able to have that. I think that's pretty special. So thank you very much. And with that, we'll go on to item number 7, which is next meeting date, September 19th. And items for future agenda, I do have something, Director Hum, with regard to this. I'm asking if we could please have, before the end of the year, a legislative session CCB policy. Basically, what that would cover is ongoing reporting to the board as we go through the session. I understand once things speed up, it'll be difficult to have you report on everything that's happening at the legislature, but then also maybe the protocol for board members as it relates to testimony and lobbying.
Absolutely.
Any other items for future agendas?
Chair, can I squeeze a couple items under here? One, can I introduce a law student at the law school, Danielle Baldwin? I just wanted to put on the record that she's here. She is the president of the law school's Cannabis Law Society, the student section. So I think hopefully we'll be hearing from that organization more, and they'll be getting more involved in law and policy, and we can all impart our wisdom on them. For future items, hopefully this is relevant to this. I was just hoping we could revisit a request that you had made in the past to have the agent that does the investigations available. I don't know if that's way too difficult, but at meetings, it'd be helpful to be able to ask the agent that did an investigation on a transfer to have them here. I remember you asking that one time, and I just wanted to follow up on that because I also think it would be helpful. And last thing, thank you to staff, because I know that this could have been hours if all their work hadn't gone into making this so streamlined. So thank you for making everything so easy.
Thank you for that, and welcome to the law student. I appreciate you being here and seeing us in action. So hopefully it wasn't too boring. It's a little fun, right? Okay, with that, we will have our final public comment. We'll go down to the south first, move to the north, and then online. Public comment in the south. Thank you, welcome, and just as a reminder, public comments limited to 3 minutes and state the name, your name for the record.
Yes, good afternoon. My name is Denise Pena. I am the founder of the International Cannabis Businesswomen Association. I've also participated locally here in Nevada with a lounge license with the social equity community. My concern right now is speaking on behalf in general of the social equity situation and the challenges that everybody's endured. A lot of people have endured as it is with existing licenses as independent license holders and the big ones, the big dispensaries as well. However, from the social equity component, I have a very personal concern because I went through the whole process. I went through the CIC process, I went through the programming, and I went through the application, and there's been a lot of things that have been very concerning to me as to how they're being handled here at the CCB with staff as it is with the investigative team. So my question is to you all, and I'm sure you all know it, how many licenses were actually approved initially with the CCB for social equity, just because I've been getting inconsistency in the answers aside from what was said publicly. And then how many are currently right now active, as well as how many have been transferred to other, transfer of the license to any other entity that is not a non-social equity applicant. And I'm putting this on the table because I'm concerned is the predatory practices in this industry with the social equity. And I can tell you that I'm not the only one experiencing this, and we're not the only ones experiencing this because Arizona is experiencing it, Illinois has experienced it. And there needs to be some kind of internal structure that we can avoid this from happening. So that we're really just putting up a front that we're helping social equity, but we're generally not doing that because we're not really creating that environment or that capacity for a social equity applicant to be successful in this industry, in any way, shape, or form. Just based on my personal experience, I've addressed it with the CCB, and I am actively working with them on the situation. But my concern here as a board is where are we with social equity here in Nevada? In terms of where we're going to move forward and what we're doing and what our capacity as applicants, participants in successful turnout versus getting the interpretation. And I gotta be honest with you, I've felt, and it's been expressed to me by other applicants, we all feel the same way in a sense of how this has been handled. And there are ways that we can pursue it as a group if we need it, find it necessary, but I find it necessary to also find ways to work together and make it doable for those that have been able to accomplish to a certain degree. But don't close the door and automatically assume that we have a predatory capitalist investor sitting there just waiting for these to be available so that they can take them on. That's where my concern is here as a participant in today's meeting. So my concern is that I hope the board is closely looking at that situation and that we are accomplishing something to social equity community, but that in another city, because it seems that that has not been fair here either, as well as that has not been fair in other states. And if we want to be the example and we want to be the ones that we got to do something about it, and I think I just don't see nothing, so I don't know where the board stands or what I would do. That's pretty much where I'm at. And I just wanted, hopefully we'll have something on the agenda with the investigators that have investigated that can bring in some input, just as was suggested, to have them here to ask them questions and give us an idea what are the challenges that they're finding, why are they not compliant, why are they not meeting the criteria, what are the issues, and where can we help them, how can we help them, how can we get local university that's offering the program, such as and the young lady who happens to be here to bring her board to also bring those resources. Those types of things are very helpful. But if we don't have it, it looks terrible. It really looks terrible, and the word is spreading, so it's obviously happening throughout the state. So before any of the reform comes into place and what have you, I think that maybe we can sit on the table, have a more of discussion to figure out what we can do for all our community and social equity. It's my thought here.
Thank you. Any additional comment in the South?
Good morning.
Please state your name for the record. And remember, we have a 3-minute policy.
For the record, Timothy Eliano speaking. Good morning, Chair, Madam Chair, and then members of and board members as well. Excuse me. I just wanted to reiterate what the lady just basically spoke on. And first, I'd like to once again thank the CCB for taking the initiative, especially I believe Executive James, for taking the initiative to I guess thoroughly investigate or whatever sort of excuse me, but whatever sort of audit that was done in reversing some of those licenses that were established that did not initially meet eligibility to begin with. Unfortunately, we haven't heard much information on that process as an interest as an applicant as well. But I am I'm hoping and determined that the board does what's right and basically honor what the legislative has basically set forth. And also in the future, moving forward, what can we, since there has been some issues that basically arose during this whole process, what are some legislative policies that could be put in place to be that would be able to basically help resurrect the program, to be honest, because it seems like even the small and small business impact, I believe the subcommittee, we haven't even heard, we don't even know if it's still in existence or not. And I'm glad that a young man by the name of David Steele had brought that to my attention from Reno. So we're still hoping for the best. And again, overall, the reason why this conversation is important is the lack of opportunity in which it basically brings forth, because if we're still looking at the demographic data that was released by the CCB once again for the 2023, we still look at the disparities between ownership, and it all trickles down. If you have a specific, group of people that are owning these licenses, there's lack of opportunity, within the industry for, experienced personnel as well. That is the main issue that we're trying to really solve here, is that we're trying to expand opportunities. Just so, it's already dominated by a specific group where, just to be politically, it's already dominated. The goal is to now just give others opportunities to also be a part of this. So,
Thank you. Any other comment in the South?
Nope, that looks like it.
Okay. Comment in the North? We have no comment in the North. What about online?
Caller with the last four numbers, 1657. Please state your name before providing your comment. Dial *6 to unmute.
Hi, my name is Abad Pisa. I'm going to refer to the notice that was released on July 2nd, 2024. That was stating that there were 6 applicants. Now, there was a specific individual who came before the board stating that he submitted those 6 applicants, which to me, since the beginning, I've been stating has been complicit with the CCB and possibly even the governor's office in committing this fraud. I'm going to call it what it is. To me, it's fraud, because these individuals pretended to be something that they were not. Not only that, but this individual was the dean of the school, and he placed himself as the dean of the school and said that he had no conflict of interest, which again is a lie, which is, to me, is fraud, stating that he had no conflict of interest. And all of this was done using public funds. So I don't understand why the feds aren't involved with this, because the CCB was created using public funds. The CIEC was created using public funds. And again, I feel like I was blatantly lied to my face, because I've been trying to get something started myself for cultivation since before 2014. I've been a patient since before 2012. I want to be a part of the game. I know what I'm doing. I don't understand how come, does the law exist? Yes or no? That's where I'm at right now. Does the law even exist? Because there's people doing these things that are outside of the law that I understand. And it's like, how are they able to get away with these things? That's all I got to say. Thank you.
Thank you. Any additional comment online?
There are no additional callers.
Okay, then we'll go ahead and adjourn this August meeting of the CCB. Thank you, and we'll see you next month.